trial division or first instance hearings and the appellate division. In the appellate division, or even in the ordinary division, you can have 1 or 3 arbitrators who are appointed to hear the case from the panel of CAS arbitrators, of which there are over 200 worldwide. It is one of the more competitive arbitral appointments that you'll find amongst international arbitrators trying to be appointed to the CAS panel, because while it might not be as lucrative as perhaps some of the more lucrative ICC arbitrations, it's certainly the most interesting. And if you look through a CAS panel as to who's on it, all of the big names in international arbitration are there, such as the gravitas of this institution and the interest in sports law in the cases it determines. Proceedings are conducted confidentially. However, unlike other arbitrations, CAS awards are public, and that's important because it comes back to the rule, what I call the rule of sports law, the determination of provisions under the World Anti-Doping Code and under the Olympic Charter. Come back to the actual wording of those clauses themselves so that the participants know. Remember what was said in Quigley and also USOC. They know what the normative environment is in which they're competing, and it highlights the predictability that is required for those rules, because sport, given that it's a rules-based activity, means very little if the people don't fully know and understand the rules by which they're competing. Very big difference between CAS and other commercial arbitration, even though it is a commercial arbitration beast, where the awards are enforced under the New York Convention. Appeal hearings in CAS, whether you get there from a domestic tribunal or from CAS ordinary division, are de novo. Costs, again, discretionary, but the subject factors of each case are taken into account in dealing with CAS. So where are we now in 2014? Well, there's been a massive explosion in CAS cases since 1984 when it was established. In 1986, there were 2 cases. You look through, I've really highlighted here on the last 12 years. And in the last 12 years, we've gone from 86 cases to 408 cases. So this is a growing jurisdiction. The cases for 2014, Matthew Reid, who was the Secretary General of CAS, informed us all in Lausanne, which James Kitching, who I see here today from the Asian Football Confederation at the CAS conference in Lausanne in September, informed us all that this year the number of filings are well past the 400, and I expect it'll probably go up close to 450. So this is a jurisdiction to be taken very, very seriously. And given that Malaysia and Kuala Lumpur is the regional centre, then plainly this is something which, with the growth of sport in the region and also with the growth of CAS, is something that's going to be very prominent for those practitioners here in Kuala Lumpur who wish to practice in this area. I won't deal with the ad hoc division today, but given the time constraints. But what we see now is the international sporting economy, and I won't labour on this for too long, it's trite as it might be, but the statistic produced by PricewaterhouseCoopers, that global sports revenue in 2015 was estimated to top $145 billion. The 2010 World Cup was watched by nearly half the world's population. I don't have the 2014 figures, but I do know that FIFA was saying that they had exceeded the 2010 figures. So given the business and economic drivers, it's no surprise, especially here in Asia as the Asian century gains momentum, that increased interest in sport is going to bring about increased participants, increased sporting disputes, and also increased disputes in sports business. So what are the 6 new challenges that I see on the horizon, moving to my second theme, and these last 2 are relatively brief, dealing with international sports arbitration, and particularly here in Malaysia. Firstly, the issue of sports integrity, that of gaming and match fixing and internet online betting on sport. Secondly, the enforceability of CAS awards. Thirdly, an accessible score of sports jurisprudence. It's all very well having these cases being handed down by the Court of Arbitration for sport, these public awards. But some of them are published on the CAS website. But a lot of these cases don't get published on the CAS website. So finding out what the different CAS decisions are is really comes down to who you know in the area and asking people, what do you have on this particular topic? And essentially this small collegiate band of international sports lawyers passing these published awards amongst themselves, build up their own personal libraries. I don't need to labour the point there to say that such an outcome on that front is highly unsatisfactory, and that the awards should be published so that they're there for all to see and to use and to rely upon. Increased sports regulation. The World Anti-Doping Code in 2015 comes into effect on the 1st of January next month. There'll be more commercial sports arbitration because of more sports business. And what I see, due to the costs of CAS and also possible developments in other parts of the world, ultimately evolving into a specialist tribunal dealing with appeals. I won't deal with match fixing and gambling in great detail because we are short of time, but suffice it to say, in cases of Oracle, Cholera, Savage, Fusama-Holy, Butt, and the like, certainly since 2010, there is much more activity in this area. And 2014, it seems every other sport now is having some sort of internal investigation being undertaken into its integrity processes and also its vulnerability to being brought down and undermined by online betting. The enforceability of CAS awards, again, I could speak for an hour on this, on Swiss Federal Tribunal decisions, and Article 190 of the Federal Code on Private International Law. I won't trouble you with that. I might not get out of KL alive if I do. We've dealt with the accessibility of sports jurisprudence. I don't know whether boring people is a criminal offence here, but I can certainly go close to doing that if I was to talk to you about Article 190 of the Swiss Federal Code on Private International Law. Increased sports regulation, we've dealt with that. What we see is interesting is a brief development in Australia. The government has jumped in. Those of you who have been following the Asada Essendon Football Club debacle that's going on in Australia, I'm a little bit constrained by what I can say given my involvement acting for some of the parties in that case. But what is interesting is, and worth looking at is after the Blackest Day in Australian sport was announced and the so-called investigation was launched into Essendon Football Club and Cronulla Rugby League Club, Asada found that it had, which is the national anti-doping regulator, found it had rather limited powers. It couldn't compel people to come forward and give evidence in the same way in which subpoenas could be otherwise. In fact, this is a subpoena case being heard today. Justice Clyde Croft is dealing with it in the, who many of you will know through the arbitration world in the Supreme Court of Victoria. And what is interesting is the government issued amendments to the Asada Act whereby the minister can issue a disclosure notice to a nominated person who doesn't have the right to remain silent and who has to actually answer questions. And in other words, it's similar to how national crime commissions and the like work. But if you receive a disclosure notice, you don't have the right to silence. You have to answer questions under compulsion so that Asada can get to the bottom of an anti-doping matter. Such a privilege doesn't matter. Any other crime, whether you're a drug dealer, you might be a murderer, you have the right to silence. But if you interfere with sport and you're involved in anti-doping activity, that's gone. Such that the rule of law doesn't necessarily apply to you. Well, it does now in a new form, I suppose, and you can be subject to a disclosure notice. Sports integrity regulation, both in terms of various government acts which are popping up in different parts of the world, but also now private regulation is something which is very prominent in international sports law at the moment. And indeed, on the sports integrity front, don't be too surprised if before the end of this decade we see a similar sports regulator, similar to that of WADA, to deal with sports integrity, or alternatively, that there's a super regulator dealing with both anti-doping and integrity to replace WADA. Murmurs at the moment seem to suggest that given that protecting sport and what's intrinsic about sport by being against anti-doping and also against match fixing, there's a lot of synergy between the roles of both anti-doping regulation and integrity regulation. More commercial sports arbitration, well, that's a no-brainer, given with more sport, more business opportunities, and given the international nature of sport, many of those cases will finish up in arbitration rather than in state courts, save those, of course, where there are issues that can only be dealt with by state courts, where, as Justice Marr dealt with trademarks, given the capacity to order the Register of Trademarks to expunge a mark is a power which could really only be directed by a state court. And then the role of CAS, given the costs and otherwise of dealing with CAS and the nature of sporting disputes becoming more complex, it may perhaps evolve. My view is it ultimately will evolve into being simply an appellate body. Meeting the future challenges. Well, good sports governance is critical. Having efficient, transparent and accountable sports structures, fair play off the field of play as well as on it, simple to easy understand sports contracts, educating well-meaning sports officials. It's amazing the number of sports disputes that emerge as a consequence of just, and I don't mean this in a pejorative sense, but ignorance on the part of sporting officials. People who volunteer well-meaningly, but they just don't know how to get it right. They don't have the tools to be able to fairly administer sport. Central and independent sports arbitration bodies to expertly and efficiently and affordably resolve sporting disputes. If there's 70 or 80 sports in a country, why are there 70 or 80 70 or 80 discrete domestic tribunals for each sport? It just doesn't seem efficient. Fencing association should have their tribunal, the football association, the swimmers. It's madness having all of these different domestic tribunals. So these are the challenges that need to be met. And the question I put rhetorically is, can Malaysia be a sports leader in the region? I believe it can. And one way it can do that is to look at a central regional sports arbitration body through the KLRCA. It's a perfect fit for this institution. And imagine if you had a central sports tribunal with a common set of rules to all sports. And any disputes that happened under sports contracts, of course, dealing with them differently for local athletes to the international athletes, could be dealt with by this central body rather than the different and disparate groups of different domestic tribunals. And deal with it rather than under the law of tribunals or the law of associations as domestic tribunals. Why not set up a private arbitration model with then a right of appeal from that central tribunal dealing with national sporting disputes to the Court of Arbitration for Sport, so that it's harmonised and consistent with the requirements of the World Anti-Doping Agency and also the IOC. And this is what it might look like. In the centre, you would have a body administered by the KLRCA, a central body. Sporting disputes, those types of disputes unique to sport, could be dealt with by this central body. Let's call it, for working purposes, MSAT, the Malaysian Sports Arbitration Tribunal. A hearing at first instance, you deal with it differently for different types of athletes. So for international and professional local athletes, common set of rules, so you don't have different procedural rules for different sports. And then the national and international athletes have a right of appeal to the Court of Arbitration for Sport, which conveniently also has a regional centre here in Kuala Lumpur. On the other hand, a lot of sports business disputes, why not deal with those by means of arbitration? Disputes between sporting organisations and sponsors, many disputes that occupy sporting administrators or general counsel of sporting clubs' time and concern are disputes over sponsorship agreements or sports facilities and the like. Bearing in mind the body of sporting expertise that you have, why couldn't that be dealt with through a different channel of the Malaysian Sports Arbitration Tribunal, KLRCA? So you look at developing a discrete capacity to centralise all of the sporting disputes here through an arbitration platform rather than a domestic tribunals platform here in Kuala Lumpur and other centres, but ultimately administered by the KLRCA. So how do we get this up and going? Firstly, one needs to obtain a commitment from the key stakeholders, namely the Malaysian Sports Council, Malaysian Government, the Olympic Council of Malaysia, Anti-Doping Malaysia, the national federations, all the different sports, and of course the athletes. They all have to buy in, and we need to get all of those people on side. And secondly, how is it established? Well, once they've committed, and we have all of our ducks or boxes lined up in a row, if you like, we then need to deal with funding. And so we have all of these institutions contributing towards the funding, ultimately of the KLRCA Sports Arbitration Tribunal, or MSAT, we call it that. Secondly, all of these bodies have an agreement on harmonised arbitration clause referring first instance sporting disputes to the KLRCA to be arbitrated in accordance with the specialist sports arbitration rules that everyone signs on to. To this extent, it does require amendment of sections 23 and 24 of the Malaysian Sports Development Act. That may well happen if this is seen to be an efficient way of dealing with these disputes. And finally, one needs to appoint suitably qualified additional panel arbitrators who have an expertise in sport to deal with these disputes. So I now conclude. It's just a thought that this might be a very efficient way of Malaysia being a regional sports leader in the way in which it deals with sporting disputes, which is consistent with the international sports arbitration framework, ultimately leading its way toward arbitration for sport. And it's important because of the increase in sport, both in terms of interest and also commercially. And there's a real opportunity because CAS is set up here, because of the interest in this country more than any other in the region in sports law and sports arbitration, to be a real leader in the region in dealing with the resolution of sporting disputes through an arbitration platform like MSAT, such as the one I've suggested. It's important also because the whole idea of sport rests on this stable foundation of fairness and transparency on and off the field of play. And if you have a central arbitration body that deals with all of these sports rather than 70 or so disparate domestic tribunals, you're well on the way to achieving that outcome and showing real leadership in this area and in the region. So, and by doing that, that will bring about, I believe, greater integrity, not just in the sport, but also in the way in which its administration operates, the rules and regulations through which athletes, the ultimate people for whom sport is there, the participants, their participation in sport is governed. I thank you for your time today. I'm sorry I've gone a little bit over time and I've skipped over some of the areas, but hopefully I've given you all something to think about. And if you have any questions about any of the matters I've raised, I'd be delighted to deal with them later on in the day. Thank you for your time.
Big thank you to Mr. Paul Hayes. A very interesting presentation and definitely something for us to ponder about. I would like to see a day when Malaysia